Okay, so I believe you can hear me now. And let's begin with the class. So today we are going to talk about insurable risks. Insurable risk with respect to the insured as well as the insurer. So what is insurable risk? When we talk about insurable risk, we are talking about the factor of insurability. That means whether a particular risk that the insured is seeking to cover can be insured or not. Not just in theory, but also practically speaking. Now, this is the job of the underwriters in the company to examine the insurance application and check whether the risk that the insured or any particular person for that matter who wants the insurance policy or even a company is trying to seek, whether that particular risk the company is trying to seek to cover, it is insurable or not. So whether the risk is insurable or not. So simply speaking, insurable risk is a situation that an insurance company will protect you against because it is possible to calculate the damages. So when we're talking about the possibility of calculating the damages, that means we arrive at a conclusion that insurable risks must be calculable. Turn off your videos, please. Okay, so insurable risk must be calculable. Are you getting my point? So therefore, what is this risk? The risk that can be covered is insurable risk. Okay, and such risks should be capable of being calculated. So thereby, it has to be calculable risks. Are you understanding me? In other words, you could also say a risk that, meets the mandate of the insurance policy, the terms and conditions of the insurance policy, or the risk that conforms to the norms and specifications of the insurance policy in such a way that the criterion for insurance is fulfilled, right? So let's move on and see what the slides say. So as an introduction, slide number 1, we talk about insurable risk, like what is the meaning of insurable risk here. So insurable risk is a risk that is capable of being insured, as I said earlier, or covered under a valid insurance policy that could be termed as insurable risk. Are you understanding me? So what is insurable risk? If I ask you what is insurable risk, and if I ask you just tell me in one sentence, your answer should be simply a risk that is capable of being covered by an insurance policy, a risk that is calculable, a risk that is admitted by an insurance company for the purpose of giving the insurance policy or for the purpose of entering into an insurance contract. So therefore, a risk that is capable of being insured or covered under a valid insurance policy could be termed as insurable risk. So thereby, the risk in question needs to conform to the criteria and stipulations of the insurance policy. Now, sometimes a risk may not be considered as insurable if it is not capable of being calculated. That means you are not able to ascertain the risk. You cannot calculate the risk, and thereby you call it as incalculable, or it is inestimable and incapable of being ascertained or defined. For example, losses to be covered as a result of war. So that is something that cannot be calculated. We do not know how to estimate or what could be the estimate in case of war. So a risk, such kind of risk cannot be covered. Or sometimes, the insurance companies do not also cover kind of risks or health risks when a person is suffering from, terminal disease. Are you understanding me? So that also comes within the ambit of a risk that cannot be covered or which is incalculable. And so therefore you cannot call it as an insurable risk. So By and large, insurable risk simply means that a risk that is capable of being insured. So, what are the characteristics or the elements that have to be present in a risk that is sought to be covered so as to enable the insurance company to enter into a contract with you? They would assess the risk that you're trying to cover and see whether the loss that is anticipated can be determined. So, therefore, it has to be a determinable loss. The loss must be determinable, measurable, and capable of being calculated. The first factor here is, of course, I went to the second part, that is determinable loss, because I felt determinable loss is an important factor as well. But apart from that, the first factor which you can see on the screen is the risk sought to be insured must be a pure risk and not suppositional or speculative. For example, windfall gains, that is lottery, gambling, etc., cannot be insured. The loss must be deciphered as an unintentional loss, which may be accidental. So the loss, therefore, should not be an intentional loss, that a person plans a particular loss, or something that, has an element of, I would call it a criminal element, because if you're trying to destroy a property deliberately, that would be considered as fraud, so as to, uh, you know, uh, gain some money from the insurance policy. You understand? So therefore, unintentional losses can be covered, but not intentional losses or losses that are deliberately effected by a person. Next is vis major. Vis major means the act of God, also called as a fundamental risk in insurance parlance, may be excluded entirely or restricted or limited under standard insurance. What is an example of act of God? Floods, storm, rain, earthquake. Rain in the sense just not the gentle and the mild rain, or just drizzle and all that. Rain in the sense rains that to such an extent that lash and create havoc and destroy property. So thereby, something that could be cataclysmic or would lead to catastrophic losses. So floods, storm, hurricane, earthquake, and so on. Next is, it has to be capable of leaning on actuarial sciences. That is, a statistical and a mathematical method of assessing financial risks. So there, probability analysis is conducted. Probability analysis, where they use statistics, mathematics, to ascertain, analyze, and advise solutions to adverse financial impact that any uncertain event that is or not foreseen may have. Thereby, actuarial science aids insurance companies in interpretatively predicting or forecasting the probability of an event and the need of fund disbursable should the event occur. Next is a probability of loss must be calculable. That means it has to be capable of being ascertained in terms of money. Next is premiums must be economically feasible. That is, the premiums that is charged should be, not a huge premium, in the sense that it's something should be affordable. So, having noted the elements in insurable risk, it can be said, therefore, that risks that exhibit the 5 elements expressed above are insurable risks. So when a question comes, what is insurable risk? You'll have to write simple definition, as well as you have to write the elements that go into determining what is an insurable risk and what type of risks are uninsurable. In the sense that the 5 elements are not present, that is uninsurable. So thereby, insurable risk is a risk that is capable of being insured and has the element of measurability, calculability, probability, and that which leans on actuarial science with economically feasible premiums can be referred to as insurable risk. Example, pure risk, property risk, personal risk life insurance, liability risk are the types of insurable risks. But what are non-insurable risks? They are those that cannot be insured, since they are indeterminable, that cannot be determined, incalculable, that cannot be calculated, improbable, that is where you cannot draw a probability, You would not understand whether it is that is possibility, sorry, and may involve, sorry, and may involve the element of speculation. Sorry. So they are often referred to as uninsurable risks. So, for example, speculative risks are windfall gains, lottery, this is reiterated here, gambling, pandemic risk, reputational risk, political risk, and so on. So, insurance companies do not cover such risks to reduce the liability and losses. And that insurance is all about pooling resources. And that's what we learned during the last class, that it is about pooling resources and disbursing or releasing it to the claimants at the time of legitimate need or at the end of the policy. Types of risks that may or may not be insurable. Broadly, risks that may be insurable can be categorized as calculable risk, also called as pure risk or insurable. And next is speculative risk. So you can bifurcate it broadly into calculable and speculative risks. Of course, there are other types of risks such as fundamental risk, static risk, dynamic risks. But broad category, of course, would be calculable and non-calculable, or calculable and speculative, or pure risk and speculative risk. Calculable risks are considered as pure risks because they are insurable. Speculative risks are something that are uninsurable, that is like windfall gains and so on. Fundamental risk, the example of that would be vis major, that is like act of God. Earthquake comes within the ambit of vis major, flood, storm, tornado, force major, like war, epidemic, pandemic, including vis major, etc. So such risks affect a large group of people or area. So it may or may not be insurable or may be limited. Static risks are risks that are untainted and clear. That is, it is clear, in fact, they're probable risk. Example, risk of theft, risk of accident, and these also come within the ambit of insurable risk. Why? Because they're static risks. They have just given some more kind of classification and they said, okay, we can call it as static risk. Next is dynamic risk, are risks that are subject to changes in the economy, as the name itself suggests, dynamic. It keeps changing. The factor of variability is here. So since such a risk is speculative in nature with three possible outcomes of either gain, loss, or break even, it is not insurable and thereby is an uninsurable risk. For example, market changes, inflation risk, political risk, reinvestment risk, and so on. Next, we have the insured. Insured, who is the insured? Who is the insured? Insured refers to the people or group of people, whether individuals or corporate, who hold or is covered under an insurance policy. The insured can also be called as the insurance policy holder. So Cambridge English Dictionary defines insured as a person or a group of people or organization that is insured in a particular agreement. West Encyclopedia of American Law defines insured as the person who obtains or is otherwise covered by insurance on his or her health, life, or property. So the insured in a policy is not limited to the insured named in the policy, but applies to anyone who is insured under the policy. So it is an insurance contract that clearly specifies the parties in the insurance policy contract, that is the insurer, the insured, the policyholder, and the beneficiaries. And on the other hand, the insurance clause that is a part of the insurance contract, which is a heart of the insurance policy contract, and that sets out the details and the scope of insurance. Next is, what is the duties of the insured? The duties of the insured. Insurancepedia elucidates or enumerates the duties of the insured as including the following: disclose material information, avoid concealment and misrepresentation. That means while procuring an insurance policy, all material information has to be disclosed or divulged. You have to avoid concealment and misrepresentation. That is, do not hide pertinent and relevant information. There should be no misrepresentation. Then report loss or damage to the authorities. For example, there is fire or accident, police report must be filed. So report losses or damage to the authorities. Provide notice of claim to the insurer. Fill in the notice of claim form and give it to the insurance company. Prepare an inventory of the damaged or stolen property and provide proof of loss to the insurer, that is the insurance company. So the inability of the insured to comply with the duties as a ground for breach of contract and cancellation of the policy or even forfeiture of the premiums paid. That means they will, I wouldn't use the word confiscate, but rather forfeit it. That means they would retain the premiums and they would not release any amount. So the inability of the insured, that is the person who's taking the insurance policy, if he's not able to comply with the duties, would it be considered as a breach of contract, or it would be considered as a person who is not honoring the part of contract or not honoring the terms and conditions of the insurance policy. And thereby the insurance company would cancel the policy straight or forfeit the premiums that are paid. Next is there are three primary duties of the insured. That is the person who has sought the insurance policy or has taken the insurance policy. It could be a person, individual, or a corporate. So the three primary duty of the insured is the duty to disclose information and reveal any incidents of damage or attach contingent risks, if any attached, that is transferred to the insurer. Failure to disclose such information may lead to the loss of insurance coverage. Next is duty to cooperate with the insurer in the identification, investigation, and resolution of any in providing all information at the time of purchasing the policy and all relevant information, reports, documents at the time of settling the claim. Next is duty to pay regular premiums. Premiums vary based on the type of insurance coverage, the age of the insured, obviously. Like the more the age of the person, the insurance policy will be more expensive. Then the jurisdictional area of the place, that is the address of the person, and the past record of the insurance claims, if any. However, if the insured fails to pay the premium as mentioned in the insurance contract, then the policy would be rendered invalid and may stand cancelled. While we understand that the insured purchases an insurance policy to safeguard against harm, losses, or damages that may be caused as a result of an event, and that the insured pays for the policy and contracts to pay regular premiums in anticipation of being compensated or indemnified, that is to make good the loss of any losses that may occur that they have sought to be protected. So not all claimants can be considered as insured. Some claimants may be policy holders, and the insured, while some may be insured under an insurance scheme of a policy holder, by virtue of which they may be considered as claimants and not insured. Let us see an example here. Say company X purchases a general liability insurance. There's a driver, and his name is Mr. Y of the company, and he inadvertently, that is by mistake, bumps into the toolkit that belongs to one of the external handmen, Mr. Z, for the company. Now here, the external handman can claim for the loss that has been caused to him from the company, which may be disbursed to the insurance company, and that this Mr. Z can be considered as a claimant and not the insured, right? If you have any questions, you can ask me. Next is the omnibus clause. Omnibus provision may be normally found in a standard automobile or vehicle liability policies that extends coverage even to persons not mentioned in the policy. The omnibus clause applies to individuals who are authorized to use a vehicle that is covered under a valid insurance policy. What gains prominence here is that the person is permitted to drive the vehicle under a valid permission, authorization sought from the owner. Next is the insurer. Who is the insurer? The one who's providing the insurance. That is obviously the insurance company. Free Dictionary defines insurer as a person or company offering insurance policies in return for premiums. Insurancepedia defines insurer as a party that agrees to compensate people, companies, or other organizations for specific financial losses. A financial loss would include the destruction of a home due to a fire or vehicle to an accident. So any event that would put the client in a lesser financial state that before the event occurred. So the insurance company is the insurer here, and the purchaser of the insurance would be the insured. What are the duties of the insurer? The primary duty of the insurer, that is the insurance company, is payment to indemnify the loss of the insured or the policyholder, or release the claims or third party, as the case may be, depending on the type of insurance. The next important duty is the duty to defend or pay the legal costs of an insured in case of a litigation. So, for example, say Mr. A has purchased a professional liability insurance. Professional liability insurance is an insurance that is taken by professionals. So let us, the example here is Mr. A, he owns a cosmetology clinic. He's a cosmetic surgeon, say. He owns a cosmetology clinic. I'm sure you know what's a cosmetology clinic. Like sometimes that is, cosmetic surgeries are carried out by cosmetologists, some skin issues or some grafting or whatever kind of problems is, treated by certain cosmetologists. So this guy, Mr. A, he owns a cosmetology clinic. He's a cosmetologist, and he has purchased the professional liability insurance in that he has covered one microderma abrasion treatment. Microderma abrasion treatment, that is a kind of a treatment that I think it clears the skin, or kind of abrasion treatment that is done on the skin. So that failed on a 32-year-old Miss B, and her face immediately developed pustular pimples and rashes that never got healed for 6 months. So he carried out this microderma abrasion treatment on a 32-year-old woman, and her face immediately developed pustular pimples and rashes that never got healed for 6 months, despite several treatments and administration of antibiotics. So Miss B's friend, who's a lawyer, advised her to file a case against the cosmetology clinic and Mr. A, who was a cosmetologist, for professional negligence. So in this case, Mr. A's insurer will be obligated to defend Mr. A in the civil action alleging negligence. Why? Because he has purchased a professional liability insurance. So the duty of the insurer is also, in certain matters, defend and pay for the legal costs of the insured. Next is subrogation. Now, this principle is corollary to the concept of indemnity, where in the insurance company or the insurer takes over the insured right by the insurer. Now, in simple terms, when the insurance company disburses the amount to the insured and the insured tries to make a claim elsewhere, for instance, to the court of law, then in such a situation, the amount of claim will be subrogated to the insurance company, the insurer, to the extent of the amount disbursed to the insured under the relevant insurance scheme, insurer, or on obtaining the consent of the insured, and can pursue the party that caused the insurance loss, damage to the insured, in order to recover that amount that is paid in the claim. So therefore, it is corollary to the concept of indemnity. So what is this subrogation in short? It is the substitution of one person or a group by another in respect of this insurance claim, which is accompanied by the transfer of certain attached rights and duties. So if you just split the word subro, it's also called a subro. It is a right of your insurance company your insurance company holds under your policy after they have paid a covered claim to request reimbursement from at the fault party. So in simple terms, what it is, the practice of substituting one party for another legitimately or in a legal setup. So in this kind of a setup, subrogation provides a legal right to a third party to collect a debt or damage on behalf of another party. So this means subrogation. Next is the duty to settle claims as per the terms mentioned in the insurance contract. Next is protect privacy. It is privacy and confidentiality has to be maintained of all the documents, because when you're taking insurance policy, you will give your birth details, your passport details, and all personal details. So privacy has to be maintained by, or confidentiality rather, has to be maintained by the insurance company. So therefore, they protect the privacy of the insured and the beneficiary. Next is they ascertain the risk at the time of purchasing the policy and assess the damages at the time of settling claim, depending upon the type of policy, through the team of underwriters. So who does the ascertainment of risk job, or who does the assessing part of it, is the underwriters. So what is the rights of the insurer or the insurance company? What does the insurer do? One is, upon an application for claim, intimate the insured and or the beneficiary regarding the course of investigation as per the procedure established by law. Next, the insurer shall have the right to defer payment of benefit under the insurance scheme until the insured provides all essential and relevant documents, such as proof of documentary evidence of the damage, loss caused, police reports in case of accident, etc. So the insurer has got the right to defer payment also in case of any pending litigation, civil or criminal, or under the orders of the court. Now, rights not to indemnify in case a party or the insured has already been indemnified. Rights to avoid the duplication of process and payments. And fourthly, right to deny disbursal of payment and or cancelling the policy in case of fraud, misrepresentation, concealing of material facts, and failure to pay premium. Do you have any questions on insurable risks, insurer, the insured, and the factors that go into identify insurable risk? Do you have any questions?